What I'm going to talk to you about in this short presentation is one of the first search and seizure warrants that we have experienced that was brought against a client in terms of the Tax Administration Act. The facts I will mention in a minute, but I wanted to just mention to you the relevant law that is applicable to this short lecture. Firstly, the particular chapter of the Tax Administration Act of 2011 that is appropriate is Chapter 5 that deals with information gathering. What is very important to remember from this chapter, which really commences with sections 40 and then runs through to section 66, it is divided up into really three key parts. And that is that first and foremost, if SARS is to conduct an audit or an investigation into a taxpayer, the least intrusive manner for SARS to gain relevant information or relevant material as defined in the Tax Administration Act is by way of a request for relevant material from the taxpayer. And then in addition to that, the SARS officials are entitled to question the taxpayers concerned and ask them even to come to the offices of SARS in order to answer various questions pertaining to relevant material. Those provisions are really covered in sections 45 through to 49 of the Tax Administration Act and must be read very carefully together with sections 40, 41 and 42. 42 is the section that deals specifically with informing and keeping the taxpayer appraised as to the status of the audit, and also then for SARS to ensure that they actually issue a letter of findings at the conclusion of the audit. Now, when we talk about the intrusion of taxpayers' rights, we're specifically talking about section 14 of the Constitution, which is part of the Bill of Rights, and it is one of the fundamental rights which taxpayers have. And the courts have held consistently in relation to issues surrounding the intrusion of the rights of privacy, in order for an organ of state such as SARS to justify such an intrusion, it must do so in the least intrusive manner. And in this regard, the cases which really are of importance pertaining to the intrusion and intruding on those rights in the least possible manner, so as not to encroach on the rights of privacy of the taxpayer too much, is Ferrucci versus SARS, F-E-R-U-C-C-I versus SARS, 65 SATC 47. That's the case that deals with that particular issue. Now, if SARS are unable to then obtain sufficient material, relevant material for the purposes of conducting their audit, then if you look at Chapter 5, the next intrusive step that is a greater intrusion than simply requesting relevant material or questioning the taxpayer about relevant material would then be to conduct an inquiry into the affairs of the taxpayer and subpoena whoever they want to in order to get the material, relevant material that SARS requires for the purposes of the audit or the investigation. And those are dealt with, those sections are sections 50 to 58. And if you are subpoenaed to such an inquiry, you actually have to answer the questions. And the guarantee is given to you that in answering those questions, any of the information you give under the auspices of self-incriminating yourself will not be used as evidence against you. So you're given a special guarantee for the purposes of actually giving that information. If that fails, then the most draconian power that SARS has in order to obtain relevant material, and here they've specifically got to show that there is a reasonable possibility that relevant material would be obtained by means of a search and seizure warrant against the taxpayer, and that there has been some transgression of a tax act or tax statute, and or that a tax offence has in fact been committed. Now those provisions are set out in sections 59 to 66 of the Tax Administration Act. And here the law is quite clear in terms of Haynes versus the Commissioner, 64 SATC 321, and Ferrella, Ferela Proprietary Limited, and others versus the Commissioner, 60 SATC 513, it is very clear that if a search and seizure warrant is executed against a taxpayer, that SARS must supply the taxpayer not only with a copy of the warrant, but at the request of the taxpayer, an application to the court, as well as a copy of the order of the court, and that has been upheld in a number of cases, of which I've now mentioned Haynes and Ferrella, where certainly the taxpayer is entitled to that information. Now, in this particular case that we dealt with, the search and seizure warrant was executed on a Thursday morning. The client representatives immediately telephoned our offices and requested that one of our attorneys be present at that search and seizure, which was immediately done. Now, in the process of such a search and seizure warrant being executed, the first thing that you do is you look at the search and seizure warrant to make sure that it really covers the primary important principles as set out in sections 59 to 66. And it contains a very cryptic description of what is being looked for, and then a fairly broad description of the type of information that is required. There's very little that one can do whilst the search and seizure warrant is being executed. You're hardly going to have enough time to rush off to court, but there are certain things that you can actually do at the time, which was done in this particular case. And first and foremost, it's very important that the legal representative and any representative present at the execution of the search and seizure makes sure that a very, very comprehensive and detailed inventory is done of any documentation, or as it's defined, relevant material that is removed and placed into boxes, and that the same thing be done in respect of copies of any of the electronic data. Here it's very important to differentiate between copies that are being taken and originals, because at the end of the day, this information is going to be very relevant to convincing or attempting to convince SARS that they have drawn the wrong conclusions, because they're obviously going to go through this information in order to raise or attempt to raise revised assessments. So you want to be absolutely certain that you know whether it's copies that have been taken or original documentation that has been taken, because that will be very relevant in terms of the rules of evidence down the line when the matter ultimately goes to court. So that being the case, not much else you can do whilst the search and seizure warrant is taking place.